Okay, it's still morning. Good morning, everybody. Before we begin, I would like to remind our spectators that your microphones should remain off at all times. For judges and participants, please keep your cameras on and microphones should be on mute when not speaking.
There are some people that are brave enough to make.
So this is session W3 of the Walker-Moot Supreme Court. This is taking place in the Red Bull courtroom. It is with great honor and privilege that I present to you the following justices who are presiding. I apologize in advance if I make any incorrect mispronunciations. Justice Melanie Sutton, Nelligan O'Brien Payne LLP, Justice Alex Di Giovanni, Greenhouse Law Firm and founder of Dwella, Justice Liam Cardle, Cardle Law, Justice Grant Ferguson, Stieber Burlak, LLP. Justices of the panel, I present to you in today's matter before the court, speaking on behalf of the appellant, Ms. Armstrong, Haley Berge, and Alexia Donis, and speaking on behalf of the respondent, Dr. Ward, Kia Anderson, and Renee Taillieu. I apologize if I mispronounced that name. We are here today to determine the outcome on appeal before the court on the matter between Ms. Armstrong and Dr. Ward. Both the appellant and respondent's counsel will have 30 minutes each in total, 15 minutes allotted to each council member to present their arguments to this court, including answering questions from the bench. The appellants will present their arguments first, followed by both respondents, and then a 3-minute rebuttal will follow by the appellant. I will signal to the court when there is 5 minutes left per speaker, and this will be the signal. Appellants, will you be using your 3-minute rebuttal?
We are currently undecided, but it is likely.
Okay, thank you. With that, the court now invites counsel for the appellant to begin.
Good morning, justices of the court. My name is Alexia Donis. I, along with my co-counsel Haley Berge, are representing the appellant, Ms. Armstrong. Today, I will be talking about the standard of care for medical negligence in Canada as applicable to this case. I will also discuss the appropriate standard of review on the appellate level. My co-counsel Haley will be addressing factual causation and the burden regarding non-negligent causes. Now, if the justices would like, I'm happy to present a quick statement of facts.
I don't think it's necessary.
Okay, that is all right. I would just like to remind the court that Dr. Ward completed the surgery, and post-operation, Ms. Armstrong's uterus became blocked, which led to the loss of her kidney. On trial, the trial judge accepted that Dr. Ward used a ligature within 2 millimeters of the ureter. This is an issue of fact, which is not on appeal today. The issue here for the court to consider is whether the trial judge correctly applied the standard of care. Now, standard of care is an individual element of the general negligence test. So let's break down negligence, as outlined in Deloitte and Liven. Negligence includes an owed duty of care, a breach of the standard of care, and damages caused in fact and in law by this breach. According to Critz and Sylvester, in Canada, the standard for medical negligence is outlined as follows. Every medical practitioner must demonstrate a reasonable degree of skill and knowledge and must exercise a reasonable degree of care, which would be expected of a normal, prudent practitioner of the same experience or standing. For this case, the trial judge correctly applied the standard of care. He noted the standard of care for a general surgeon performing laparoscopic surgery as identifying, protecting, and avoiding direct contact or close proximity to the ureter when using a ligature. Therefore, breaching the standard of care would be to touch the ureter or come within close proximity of it during a routine colectomy on a benign colon. Now, my friends say that the trial judge erred because he required the standard to be one of perfection, to not injure the ureter. But this was not the trial judge's conclusion. All of the expert witnesses at trial agreed that a general surgeon must take steps to identify, protect, and avoid contact or close proximity to the ureter when using the ligature, as outlined by the trial judge. The experts described close proximity as within 1 or 2 millimeters of the ureter. At trial, Dr. Ward even agreed that a surgeon must dissect far enough away from important structures to avoid damaging them by thermal spread.
But counsel, can I ask a question?
Yes.
Are we not saying that, or is the issue not that it's not really a standard of perfection as much as it is we're saying, well, there's damage to the ureter, therefore there must have been negligence on the part of the doctor?
Well, we aren't exactly looking at a perfect result here. We aren't trying to analyze the result. And as my co-counsel Haley will go into, we can use factual causation, some circumstantial evidence, in order to understand the standard of care. But we are looking at the means, the conduct of the surgeon. So yes, at the end of the day, the ureter was damaged. However, we have to look at, was it damaged negligently through negligent action? Does that answer the justice's question?
Yep.
Perfect. So the trial judge had to determine whether Dr. Ward had acted as a reasonably prudent and diligent surgeon by identifying and protecting the ureter. The experts outlined how to do this. Stay away from the ureter. My friends also rely on Filoka and Pinkertons to argue that the trial judge created an absolute standard instead of one rooted in reasonableness. But this is not Filoka. In that case, the trial judge erred both by imposing an absolute duty and by failing to articulate what the defendant was actually required to do to discharge that duty. Here, the experts informed the trial judge on what was required. You identify the ureter and you protect it by staying away from it. My friends also raised Carlson and Sutherland. In Carlson, the trial judge focused on the result of the surgery and not on the precise manner in which the surgeon failed to meet the standard of care. But in this case, the trial judge accepted that Dr. Ward used a ligature within 2 millimeters of the ureter. This is a finding of fact, which is again not on appeal today. So it's not disputed here that there are steps that should be taken. The dispute is whether the majority at the appellate court was content with Dr. Ward meeting some of these steps, not all of them.
Did the trial judge find that the device was used within 2 millimeters, or did they find that it was possible that it was because he didn't know exactly where it was at all times?
Based on the evidence at trial, the trial judge concluded that Dr. Ward used the ligature improperly within 1 or 2 millimeters, so close proximity.
But was that because there was damage to the ureter that they decided that really, because the ureter was damaged, therefore they must have used the tool within 2 millimeters?
Well, it wasn't a matter of must have, because if there were any non-negligent causes brought up at trial, the trial judge considered them and then dismissed them. And my co-counsel Haley will go further into non-negligent causes. But at the end of the day, through the expert evidence presented at trial, also using factual causation, this is the decision and the conclusion the trial judge came to. So truly the dispute here is that the trial judge required all of these steps, identify, protect, stay away from the ureter, to be met. And Dr. Ward did not meet the final step of staying away from the ureter. So the trial judge correctly noted this as a breach of the standard of care. And we're not here to talk about a perfect outcome or to argue. This is not on the table today. We are here to discuss the appropriate steps that a reasonable or competent surgeon should take. This is a standard of reasonableness, void of perfection. Simply, Dr. Ward did not take all of the necessary steps. Now, the goal of the surgery was to remove the colon. It was a colectomy using laparoscopic procedure. My friends raised that the trial judge falsely relied on the goal of not injuring the ureter, which would focus on results in perfection. They preferred to categorize it as a step. That's fine. The controversy between goals and steps is simply semantics. You can break any particular surgery or goal down into steps. The goal was to perform the procedure properly. And in order to do this, you must follow certain necessary steps, like staying 2 millimeters away from the ureter. So let's say a surgeon is performing a tonsillectomy on me. The goal of the surgery is to remove my tonsils, and my surgeon successfully does so, but in the process knocks out some of my teeth. Has the standard of care been met? While my surgeon met the goal of removing my tonsils, the standard is not entirely fixated on this. My surgeon did not take all of the necessary steps to protect my mouth, just like Dr. Ward did not take all of the necessary steps to identify, protect, and stay away from the ureter. The standard of care is based on the means, the conduct of the surgeon. So while Dr. Ward completed the surgery, he performed it negligently. I would now like to turn the court's attention to the issue of standard of review. For the standard of review, the appellate court inappropriately applied a correctness standard. While this standard is utilized to review questions of law, like the articulation of the standard of care, it is not used to determine whether this standard was met. That is a question of mixed fact in law. And review of fact only pertains to palpable and overriding error. This examines whether the trial judge was clearly wrong, palpable, in a manner that had an effect on their decision, overriding. Negligence and causation, as we are talking about it today, are matters of fact. Since there was no palpable or overriding error, deference must be afforded to the trial judge when considering the factual instances of the standard of care.
Counsel?
Yes.
If I may ask a question, please. Does not the appellant court consider the standard of correctness with regards to the standard of care, and that is a question of law, not a question of mixed fact and law? And then they go on to apply a different standard, of course, to questions of mixed fact and law. But shouldn't ultimately whether the standard of care was met be evaluated on a standard of correctness?
So thank you for bringing that to the attention of the court. We are submitting today that while the articulation of the standard of care is an issue of law that is reviewed on the standard of correctness, the way we are looking at it to determine whether the standard was met is an issue for the trier of fact, which we could consider mixed law and fact. So we are looking at the factual component of it. Does that answer the justice's question?
I would ask, in terms of the standard of care being applied, though, are you saying that that is a question of mixed fact and law?
Yes, that is what we are submitting.
Thank you.
So at the end of the day, the trial judge outlined the standard of care as identifying, protecting, and staying away from the ureter. All of the experts on trial agreed that these are crucial steps. We aren't arguing here for a perfect result or an outcome. We are simply saying there are things you should do and shouldn't do. You should remove the colon, let's call it a goal, and you shouldn't injure the surrounding organs by adhering to careful conduct, and we can call those steps. These are instances influenced by fact, which affords deference to the trial judge. Since there was no palpable or overriding error, this reasoning should not be disputed. Now, my co-counsel Haley will discuss factual causation and non-negligent causes. I'd like to thank you, justices, for your time, and if you have any further questions, I'm happy to answer them.
Thank you for your time today, justices. My name is Haley Berge, and I will begin by picking up where my co-counsel left off. So I think it is worth restating that the trial judge's opinion is entitled to deference. I would also like to point out right away that we are not discussing issues of dexterity, nor are we weighing the expert witnesses' opinions against each other. Instead, the issue that we are discussing today is whether or not the trial judge was incorrect in bringing factual causation to assess whether the standard of care was breached. So at the Court of Appeal, the majority maintained that the trial judge erred by conflating the standard of care with causation. They argued that the issue of causation should be addressed only after the trial judge has determined if the defendant has breached the standard of care or not. It was stated that to do so amounted to an outcome-oriented approach or backward reasoning. While in general, we do accept that it is true that the issue of factual causation arises after the trier of fact has found that the defendant breached the standard of care, there are, however, cases, such as the one at bar, which require factual causation to be determined in order to decide whether the standard of care has been breached. So after determining what happened, it can then be decided whether or not that conduct in question falls below the standard of care or not. So in this case, the trial judge made the finding that Ms. Armstrong's injuries were caused by the thermal spread of the ligature before he concluded that Dr. Ward breached the standard of care by operating within 1 to 2 millimeters of the ureter. Doing so was not a mistake. Again, we submit that the trial judge did not err by determining the factual causation of the injury before concluding that Dr. Ward breached the standard of care. In fact, in certain circumstances such as this one, it can be considered essential that the trial judge makes a determination of the factual cause of the injury before turning to the standard of care assessment. This issue was—
Question for you: is there not a risk there of this creating a situation where you have a standard of perfection, or you can look at it really as a bias against the defendant, the defendant doctor, in that, I mean, really what the concern about what's happening here is okay, there was damage, therefore it must have been negligence. I mean, really, does that not create a slippery slope and a risk for bias in the future when a court looks at matters in this way?
Thank you for your question, Justice. And I see where you're coming from and that this is a cause for concern. However, I would like to point out that the way that factual causation can be used as circumstantial evidence is determined on a case-by-case basis and is not an absolute requirement, nor is it something that might commonly happen. However, with the case at bar, the trial judge did consider that this would be a preferable or a necessary step to determine what happened before then turning to the negligence assessment, which then causation in law would be determined, which differs from the causation in fact.
As a follow-up to that, counsel, what do you make of the fact that Dr. Ward stated that he did stay 5 centimeters away from the ureter?
Thank you for your question, Justice. So you are correct. Dr. Ward maintained throughout the trial that he stayed 5 to 10 centimeters away from the ureter during the operation, which is quite different from the 1 to 2 millimeters. However, based on the expert evidence that was presented at trial, and also the evidence, the non-negligent causes that were ruled out by the trial judge did accept that Dr. Ward used the ligature within 1 to 2 millimeters of the ureter. And as my co-counsel was discussing, the trial judge is owed deference in regards to these facts that were found at the trial.
Counsel, let's go one step further with that. Again, I come back to this. Was there actual evidence that the tool was within 1 to 2 millimeters of the ureter, or is that the inference that's drawn because there was damage?
So in this case, Justice, it's considered that there was sufficient circumstantial evidence to make such an inference. And that is based on the expert witnesses giving their opinions on this particular surgery. It was called Surgery 101, that any reasonable or prudent surgeon would have no issues performing this surgery, particularly because Ms. Armstrong's colon was anatomically normal. It was benign. So to give you a reference to that, it would be like working with a blank canvas or sailing a boat on calm seas versus going into a storm. Okay, so to continue on, as I was talking about with the issue of factual causation, it was addressed in Grass and Women's Hospital and then later clarified in Leone and Peters, where the court stated that while it is not a steadfast requirement, it is sometimes preferable to determine factual causation prior to determining if there was a breach of the standard of care. And because of this, we submit that the dissenting opinion of Justice Rendsburg should be followed. So it is important to note that factual causation is different from causation in law, also known as but-for causation. Earlier, as my co-counsel explained, factual causation deals with what actually happened during the surgery. These are the facts that explain how the surgery happened or how the injury happened. But-for causation is part of the negligence test that is dealt with later on in the legal analysis. And at that point, a question similar to, but for Dr. Ward coming within 1 to 2 millimeters of the ureter, Ms. Armstrong would not have been injured. So the trial judge's consideration of evidence which explained what happened, again, the factual causation, before reaching a conclusion on the standard of care assessment was not an error. The type of causation that was used as circumstantial evidence by the trial judge was factual and was not causation in law. Therefore, no error was made. Consideration of factual causation does not amount to conflating standard of care and causation. The trial judge determined both the causation and the standard of care by relying on the strong expert evidence that was presented at trial. It was stated on appeal that there was little difference between the standard of care evidence of the expert witnesses. Ultimately, the trial judge accepted Dr. Bernstein's evidence that Dr. Ward came within 1 to 2 millimeters of the ureter during operation, which resulted in scarring, the blockage, and ultimately the removal of Ms. Armstrong's kidney. Having strong and consistent evidence at trial is important in determining the cause and fact of the injury. If the plaintiff's injury provides sufficient circumstantial evidence to allow the trier of fact to infer a breach of the standard of care, then this is acceptable. In this case, Ms. Armstrong's injuries provide sufficient circumstantial evidence. Again, I want to remind the court that the trial judge's opinion, in fact, is owed deference and that we are not disputing issues of fact today. Next, I would like to turn the court's attention to the obligation regarding non-negligent issues. In a medical malpractice case, the plaintiff is not required to disprove all possible non-negligent causes. In particular, there is no onus on the plaintiff to disprove theories that are only raised on appeal and not at trial. The majority states that it was an error to not address various non-negligent causes such as dexterity or periodic vermiculation unexpectedly causing strictures to move during surgery. However, it is well understood that during a trial, parties must present their best evidence and advance their strongest arguments to support their cases. What is not advanced at trial does not need to be considered by the trial judge, nor does the plaintiff bear any onus to disprove evidence that is not at trial.
So another question for you. Do you agree that that the way that this was approached was again not to apply the but-for test?
Sorry, Justice, do you mind rephrasing your question?
Do you agree with me that the trial judge did not apply the but-for test here?
During the beginning part of the trial, if I understand your question correctly, his first determination of factual causation did precede the standard of care assessment. So in that sense, no, I do not think that the trial judge employed but-for causation when determining factually what happened during the surgery to cause the injury. If that answers your question, Justice?
Yeah, and then so the next part of that is, you know what, I've drawn a blank, just continue and we'll come back to that.
Of course, Justice, anytime your question comes back to you, please just let me know. Okay, so what is not advanced at trial does not need to be considered by the trial judge, nor does the plaintiff bear any onus to disprove evidence that is not called at trial. The Court of Appeal noted that it is trite law that a trial judge must decide a case on the evidence and only on the evidence presented at trial. Because of this, it is submitted that the trial judge did not err by not considering other non-negligent causes. Additionally, it is submitted that the plaintiff also has no responsibility to disprove non-negligent causes. In fact, considering outside evidence would have been a judicial error. For example, no evidence was raised which theorized that Dr. Ward was physically pushed in the middle of surgery or that there was an earthquake causing the injury to the ureter. It would therefore be inappropriate and unnecessary for the plaintiff to lead evidence to try and disprove that Dr. Ward had not been physically pushed or that there had been an earthquake during the surgery. If a non-negligent
Counsel, I'm gonna stop you there. So just quickly, because I know you don't have a ton of time left. So if you're in agreement that but for wasn't applied by the trial judge, is it not almost essential for the plaintiff to really establish that there could have been no other outside cause and only possible option was coming too close with the medical device?
Thank you for your question, Justice. And I think that is an important question to raise. And I would like to remind the court that the onus is on Dr. Ward, the respondent, to have that evidence at trial, and also to consider that Dr. Ward was in the best position to lead evidence. In fact, as we know, Ms. Armstrong was unconscious during the surgery. So if Dr. Ward had other non-negligent causes of the injury that he wished to raise, then that should have been led with at trial. Does that end?
Yep, thank you.
Perfect. Okay. So if a non-negligent cause is not raised as evidence at trial, then the trial judge need not consider it. In Hassan and Vari, it was said that a trial is not intended to be a scientific exploration with the presiding judge assuming the role of a research director. Rather, it is a forum established for the purpose of providing justice for the litigants. As well, it is important to note that the trial judge actually did address the potential non-negligent causes which were raised at trial, and then he rejected them. In his testimony, Dr. Ward maintained that he stayed 5 to 10 centimeters away from the ureter during the entire procedure. And because of this, he theorized that his use of the ligature several centimeters away from the ureter was what caused the damage. No other non-negligent causes besides this one were raised at trial by the respondent. If the respondent wished to raise issues such as dexterity or unexpected movement of strictures during surgery, then he should have done so at trial. The same logic applies to the plaintiff. There is no onus on the plaintiff to disprove non-negligent causes. So the appellant seeks an order setting aside the judgment of the Ontario Court of Appeal, restoring the trial judgment with cost throughout. That concludes the appellant's position. Thank you very much for your time today, Justices.
The court now invites counsel for the respondent to begin.
Thank you. Good afternoon, Justices. My name is Kaya Anderson, and this is my co-counsel, Renee Taillieu. Today, we will be representing the respondent, Dr. Colin Ward. I will begin with a brief roadmap, followed by our submissions. So first, I will be explaining why the Court of Appeal correctly fixed the legal mistake that the trial judge made by defining the standard of care as a goal. Second, I will turn to the question of standard of review and why the appropriate standard to be applied is correctness, because the trial judge made a legal error and not a factual error. My co-counsel will then explain why causation should not be used as circumstantial evidence to inform the standard of care. Lastly, she will explain why the Court of Appeal was correct in their statement that the plaintiff can have the duty to rule out non-negligent causes. So beginning with the standard of care, first I will explain how the trial judge erred and created a standard of perfection and why the Court of Appeal was correct in rectifying this error based on the relevant case law. Second, I will clarify why the issue of staying away from the ureter is a goal and not a step and is not simply semantics. Lastly, I will shed light on why the court must remain extremely cautious in not implementing a standard of perfection in medical negligence cases. So first, at issue is whether the trial judge applied a proper standard of care to determine whether Dr. Ward fulfilled his duty to Ms. Armstrong. Unfortunately, the trial judge erred and created a standard of care that was based on results and not means. The Court of Appeal corrected this error and using the trial judge's findings of fact to find that Dr. Ward was not negligent. So to determine the correct standard of care, one must ask whether the defendant behaved as a reasonably prudent and diligent fellow professional would under the same circumstances. The trial judge began his conclusion with these very determinations and found that a reasonably prudent and diligent professional would take steps to identify, protect, and avoid the ureter in his conclusion using the expert evidence presented at trial. These steps included checking and rechecking the location of the ureter, steps the trial judge found Dr. Ward to have followed. However, instead of using these steps as the standard of care, he ultimately and incorrectly concluded that it would be a breach of the standard of care for a general surgeon to touch the ureter or to come within 2 millimeters of it.
Counsel,
Yes.
explain, would the but, in your view, or in your submissions, would the but-for test work in this case?
In our submissions, we would say that yes, the but-for test would work. However, you must use the standard of care to go through and see what, to find and point to that negligence. And we submit that that cannot be done with the steps in this case because Dr. Ward did follow all of those steps.
Can you just explain to me briefly how the but-for test would work?
Yes, so but for Dr. Ward's negligence, the injury would not have occurred. So we submit that that is not the case because there is no point of Dr. Ward's actions that we can point to and say that those actions were negligent because he had followed all of the steps that the trial judge had laid out in the beginning of his conclusion.
Is that not the main reason, though, that we want to look at the facts first and look at the injury first and work backwards and say, well, how else could this have occurred? There's no other explanation for it. So in the balance of probabilities,
yes, so my co-counsel
must have come
right.
too close.
Mm-hmm.
Go ahead.
Sorry. So my co-counsel will be talking more about using causation in that analysis, but I think I will be highlighting the importance of not working backwards because that does lead to hindsight bias, and especially medical negligence cases. When us lawyers are looking at these cases, we don't always know, we can have hindsight bias when we start backwards working from the injury. So it's very important to go through the steps and the steps of the standard of care to make sure that the doctor followed all of those steps.
Counsel?
Yes.
Wouldn't you say that in a case like this, I mean, the appellant lost a kidney, it's kind of a severe result. Shouldn't that result influence the analysis and in the standard of care?
So at this point, I do not think that should influence the standard of care. I think there's very small things in medical cases that can lead to extremely tragic results, problems with anesthesia, allergies. Of course, that's not the case here, but there are small examples of small things in medical cases that lead to such tragic injuries that we do run the risk of finding an unfound case of negligence if we look at that tragic injury first. So, however, instead of using the steps as the standard of care, the trial judge ultimately and incorrectly concluded that breaching the standard of care would be for a general surgeon to touch the ureter, come within 1 to 2 millimeters of it. So this made the standard of care dependent on achieving the goal of not coming within 1 to 2 millimeters of the ureter. In doing so, he created an absolute duty on Dr. Ward and held him to a standard of perfection. So the applicants propose that the standard of care is not predicated on a goal, and they refer to the difference between a step and a goal in their factum as simply being semantics. However, we suggest that this is incorrect because not injuring is a standard of means. So how do you achieve the goal of not injuring? And we submit that that is by trying to stay away from the ureter through the use of periodic checking and rechecking, which is a step that Dr. Ward took. We propose that there's no step that Dr. Ward did not follow if the legal mistake is corrected. So the case law in this regard is very clear that it is a legal error to create a standard of care that's predicated on a goal or result. So in Filoka and Pinkertons, the trial judge found that any unauthorized person entering the mine that the Pinkertons had been hired to guard would be in breach of the standard of care, regardless of the reasonable steps the Pinkertons took to prevent that from happening. The Supreme Court said that the standard of care created by the trial judge was incorrect because it was an absolute standard. And of course, here the case is much smaller, but essentially the same mistake was made by the trial judge, that the result or presence of something signaled negligent actions. So this is an attractive inference to draw because it's deceptively simple. However, courts have repeatedly cautioned about the danger of drawing this inference in medical negligence cases. So for example, the Supreme Court in Saint-Jean and Mercier cautioned against using this erroneous goal-driven approach described above because it runs the risk of focusing on the results instead of the means. And as we know, professionals have an obligation of means and not an obligation of results. This sentiment was also echoed by the BC Court of Appeal in Carlson and Sutherland. So in Carlson, the facts were very similar to the facts of our case. The trial judge inferred that because the surgeon had inadvertently cut blood vessels, that negligence was prima facie established. So the BC Court of Appeal corrected the trial judge's formulation of the standard of care and reversed the finding. So as I said before, my co-counsel will be expanding on the dangers of hindsight bias in her submission, but it's important to remember that we are here to assess the means that Dr. Ward took and not work backwards from the injury. Like the applicants have stated, this was surgery 101, but we cannot assume that a medical error cannot happen or else that would be a standard of perfection. So subject to any questions on that issue, I will be turning to the issue of standard of review. So I'll just begin with a brief roadmap on the issue of standard of review. So first I'll explain why the applicable standard of review for the issue is correctness. And it's correctness because correctness is the standard of review for legal errors. Second, I will explain why this is a legal error and not a factual error or a question of mixed law and fact. And then I will show that the Court of Appeal did indeed apply this correctness standard properly. So to begin, the applicable standard of review for legal error is correctness. The issue at hand is an error of law. That error being that the trial judge erred in defining the standard of care that Dr. Ward had to meet and improperly established a standard of perfection. It's clear from the case law that the appropriate standard of review for a legal error is correctness. And the authority for this is Housen and Nicolason, my apologies. So also citing Housen, the applicants have proposed that this is an issue of mixed fact and law, subject to review of palpable and overriding error. We submit that this is an incorrect interpretation of the issue at hand. The issue is clearly a legal error because it involves the legal component of the standard of care, not the factual findings of the trial judge, because that would make it subject to palpable and overriding error. So the factual findings of the trial judge.
How do you examine standard without including any facts in that analysis?
So we submit that the facts were considered in that analysis, and I think that's shown by the Court of Appeal respecting all of the facts that the trial judge found. But what they pointed to, the legal error they pointed to, was within the standard of care and how those facts were kind of defined. So we submit that the facts were still used and shown deference, but if that legal error corrected within the trial judge's defining of standard of care, if that's corrected, using all the same factual findings, Dr. Ward can be found not negligent. Did I answer your question? So the factual findings, as I just mentioned, were respected and shown deference, and the judge's factual findings, the Court of Appeal stated that if the error was corrected using the factual findings of the trial judge, Dr. Ward would be found not liable. So questions of mixed fact and law are questions about whether the facts satisfy the legal tests. And here the question is about the actual legal test, the standard of care. So Housen highlights this kind of very example where a question of mixed fact and law can be a purely legal question in the circumstances of a negligence finding that rests on an incorrect statement of the legal standard. So simply put, the legal error here being corrected rests within the standard of care, not the application of the facts to a correct standard of care. So lastly, the Court of Appeal properly applied this correctness standard. They made it clear that correctness was the standard being applied, and the language and reasoning used by the majority in the conclusion also supports that it's a question of pure law being corrected. Great deference was given to the judge's factual findings, and we do not dispute the factual findings of this case, only the standard of care that the judge imposed. So subject to any remaining questions, that concludes my submissions, and I will turn the floor to my co-counsel.
Good afternoon, Justices. My name is Renee Taillieu, and I am co-counsel for the respondent physician, Dr. Colin Ward, along with Kaya Anderson. So I will now present our next two arguments. First, I will argue that the Court of Appeal was correct in their finding that the trial judge erred in using causation as evidence to determine the standard of care. Second, I will argue that the Court of Appeal was correct in their statement that a plaintiff can have the duty to rule out non-negligent causes in some cases. So first, I will turn to the issue of conflating the causation analysis with the standard of care. The trial judge incorrectly used causation as evidence to inform the standard of care, and the Court of Appeal appropriately identified this error. Tort law is grounded on the principle that the elements of negligence must be found sequentially, and that if one element is proven, the analysis cannot proceed. Thus, causation can only be examined once a breach of the standard of care has been found. Despite his correct statement that courts are required to determine what the standard of care is and whether it has been breached before analyzing causation, the trial judge went on to use the inference that Dr. Ward caused the injury to Ms. Armstrong's ureter to inform the standard of care as being to identify, protect, and avoid contact with or close proximity to the ureter with the ligature. Justice Pacheco correctly identified this error, finding that had the trial judge applied the correct standard of care, he would not have needed to conflate the issue of causation with the standard of care decision. Generally, the use of causation as circumstantial evidence to inform the standard of care has largely been rejected. In McCardle Estate and Cox, the court stated, "It is a critical fault to reorder the negligence analysis by placing the causation analysis before that of the standard of care. How can a judge decide whether, but for the defendant's substandard action, the plaintiff would not have been injured if the characterization and application of the standard of care decision depends on the causation decision? The suggestion that causation should be analyzed before standard of care is truly putting the cart before the horse." In Befaro and Dowd, Justice Laskin explicitly rejected the appellant's arguments that the trial judge erred by not considering causation before the standard of care. Specifically, the appellant in this case argued that the trial judge should have made a finding of fact that a burn caused his fistula, so he could use this as evidence that the physician breached the standard of care by failing to detect the burn. Similar to Befaro, the Court of Appeal in this case, Justice Pacheco, found that the trial judge had erred in looking at the cause of Ms. Armstrong's injury to her ureter before determining whether the standard of care was breached. The court
Counsel, I keep coming back to this. Do we not have evidence at the trial level that there were times when the doctor was not aware of where the device was? And we don't have any other explanations for how the damage to the ureter was caused. The balance of probabilities, is it not the logical answer that he must have come too close?
So to answer your first suggestion about the laparoscope, Dr. Ward did admit, and his experts, that during the surgery, the entire field or plane of surgery is not in view, but that checking and rechecking the ureter is the standard of care in laparoscopic surgery. The fact that the plaintiff's expert said that it should be in view at all times is different, and I would argue not applicable, because he doesn't perform the surgery laparoscopically, he performs it openly. So of course he can see everything at all times. But performing a surgery with a laparoscope is a completely different operation, and the standard as provided by our experts is to constantly check and recheck the ureter that it is out of view, or sorry, that it is away from the current surgical field. Does that answer your question?
Yeah, thank you.
Okay. So this error illustrates the phenomenon of hindsight bias, which manifests in the tendency to exaggerate the extent to which a past event could have been predicted beforehand. Since medical malpractice cases always examine the care of the physician retrospectively, judges and jurors ought to be mindful of hindsight bias when rendering a verdict. Warnings of hindsight bias are well established in the jurisprudence. In Johnson and Hayter, the court stated that the injury itself cannot be a factor used to dictate a finding of negligence, because even though the injury occurred, it could have occurred when the surgeon was using the utmost care, and it is the level of care that is the issue in a malpractice case. In Terneuzen and Korn, Justice Sapinka emphasized that courts must not, with the benefit of hindsight, judge too harshly doctors who act in accordance with prevailing standards of professional knowledge. For the trial judge to use the injury to Miss Armstrong's ureter as evidence Dr. Ward breached the standard of care was also contrary to the warning in Lapointe and Hôpital Legata that courts should be careful not to rely upon the perfect vision afforded by hindsight. Otherwise, the doctor will not be assessed according to the norms of a reasonably prudent doctor in similar circumstances, but rather will always be held accountable for mistakes that are apparent.
Sorry to interrupt you, if I may ask a question on that point. Isn't it open to the trier of fact to rely heavily upon the evidence of an expert like Dr. Bernstein for the plaintiff to ascertain that the causation and the standard of care are interrelated? And it's not an error, it's simply a choice that the trier of fact found Dr. Bernstein's evidence to be sufficiently persuasive, and that itself is not an error.
Could you rephrase the question a little bit? Sorry.
Sure. So you're addressing the issue is fundamentally it's hindsight bias, but the trier of fact is open, is he not, to make the decision based upon the evidence of one expert over the other. And Dr. Bernstein was quite clear that it was impossible for this procedure to have been done correctly if the proper steps were followed. And didn't the trier of fact simply accept that expert opinion? And there's no hindsight bias here at all.
So I would argue that, first of all, Dr. Bernstein did not state that it was impossible. I believe he did state that there was zero risk, but this was not supported by the literature. And the other physicians stated that while the risk should be low, it's not impossible, and that an injury to the ureter can result without negligence, albeit a very small risk, which was minimized by the fact that she had no pre-existing conditions. However, I would argue that there is hindsight bias in this case because the trial judge's order of analysis focused on the fact that the ligature, in his opinion, came too close to the ureter, caused the injury, and then so the standard of care was essentially not to cause the injury. The trial judge in our submissions did put too much weight on the cause to the injury in his defining of the standard. The standard should have been just the steps that a reasonably prudent physician would have taken in similar circumstances. The standard should not have been don't injure the ureter.
Thank you.
Okay.
Counsel, so is your position then that evidence of the causation of an injury should never be assessed prior to the standard of care?
So not the evidence, Justice. That would not be our main argument, is that it can be examined and looked at as to potential causes of the injury, especially in surgical cases. But in our submission, the trial judge placed too much weight on this causation evidence, and he could have used it to make an inference at the beginning without using it to define the standard of care. In our submission, the trial judge did not say what else Dr. Ward could have done except not cause the injury, essentially, which in the literature, there is a small percentage of chance that this injury can result without negligence on the part of the physician. So Dr. Ward is not aware of what else he could have done in the circumstances except not cause the injury, which in medical malpractice cases is not how the analysis is supposed to proceed. It's supposed to stop once the standard of care of a reasonably prudent surgeon in similar circumstances has been met. So it should have stopped after finding that Dr. Ward performed all the steps that were stated by the experts. Does that answer your question?
It does, thank you.
So this error was also identified in St. Jean and Mercier, where the Supreme Court upheld the Court of Appeals finding that the trial judge erred in using the injury to define the standard of care. So here the Supreme Court stated that whether a specific positive act or an instance of omission constitutes a fault is to collapse the inquiry and may confuse the issue and run the risk of focusing on the result rather than the means. As my co-counsel Kaya stated earlier, professionals have an obligation of means, not result. The error in this case occurred when the trial judge conflated the standard of care and causation analyses, using the result to define the standard. The trial judge used the injury to the ureter, which he said was caused by the ligature, to define the standard as don't injure the ureter with the ligature. So subject to any remaining questions, I will now be turning to the issue of the duty to rule out non-negligent causes. So the Court of Appeal was correct in their statement that the burden to rule out non-negligent causes can fall to the plaintiff. I'd first like to point out that we aren't presenting this argument in an attempt to overturn the long-standing rule in Fontaine that the burden of proof to rule out non-negligent causes falls to the defendant in the majority of cases. Instead, we merely agree with the Court of Appeal's finding that in specific situations, such as when a trial judge chooses to proceed on the basis that only negligence could have caused the injury in question, that this burden would then fall to the plaintiff. In the case at hand, the application of this finding is somewhat complicated because if the trial judge had properly conceived of the standard of care, the plaintiffs would not have had the duty to rule out non-negligent causes. But because the trial judge chose to proceed on the basis that only negligence on the part of Dr. Ward could have caused the injury to Ms. Armstrong, he would have needed to rule out other possible non-negligent causes first, which should have been advanced by the plaintiff. This way, the trial judge would have properly been able to use success as the standard of care. The appellants make the argument that placing the burden of proof on a victim in negligence cases is unjust, since the patient usually does not know the details of how the surgery proceeded. And generally, we agree with this point. It, of course, is much more difficult for the patient to know what occurred during their surgery than the physician who performed the surgery. That's why in the majority of cases, the plaintiff only has to provide enough circumstantial evidence for the judge to make an inference of negligence, and the defendant has to provide their evidence to the contrary. It is also important to bear in mind that it's not the plaintiff, but their expert that would provide the evidence. So surely other general surgeons are capable of providing evidence of possible non-negligent causes of the injury to the ureter in this case. So for these reasons, we respectfully request an order dismissing the appeal before this court and upholding the judgment of the Ontario Court of Appeal in favor of the respondent physician, Dr. Colin Ward. Thank you.
I'd like to ask counsel for the appellant if they would like to use their 3-minute rebuttal now.
Yes, we would like to use our 3-minute rebuttal now. Thank you.
Okay, please go ahead.
First, I would like to note that the trial judge did not only consider results nor rely on them. He correctly analyzed the means based on the expert evidence provided. The means are these steps, as outlined on page 6 of our factum. The means are based on what a reasonable surgeon with like experience and standing would employ. Even Dr. Ward himself admitted that if he used the ligature within 1 to 2 millimeters, it would have been an error. It is clearly a step that should be taken. And again, this is not Faloka. The means, the steps, and the how are provided by the trial judge. Now, on the issue of the standard of review, whether the standard of care was met is an issue for the trier of fact. So this must be reviewed based on palpable and overriding error. My friend said that the issue was about how the facts were defined, despite accepting that these facts are owed deference. From a legal standpoint, the trial judge adhered to the standard of medical negligence in Canada by ensuring this reasonableness was based on care, skill, and like standing or experience. This was achieved by considering the expert evidence regarding expectations of reasonable conduct on an anatomically normal colon. It was ideal conditions. Now, in regards to circumstantial causation, or factual causation used as circumstantial evidence, my friends seem to regard the Grass and Women's and similar cases as stating that it is not an absolute requirement that factual causation should be examined prior to the standard of care. It is not, nor are we submitting that it is an absolute requirement. Rather, there are certain cases, such as this one, where determining what happened prior to the standard of care is acceptable and even beneficial. If the plaintiff's injury provides sufficient circumstantial evidence to allow the trier of care or the trier of fact to infer a breach, then this is acceptable. And lastly, on the submission of non-negligent causes leading to potential hindsight bias, I would like to address this concern. So in the Johnson case, it was suggested that even a surgeon employing the utmost care could result in injury. This would suggest non-negligent reasons caused the injury. This brings me back to my discussion on how non-negligent causes are addressed in the court. If evidence of some non-negligent cause was not led by the respondent at trial, then it need not be considered now. In fact, to do so would be a judicial error. And let us not forget that Dr. Ward was in the best position to lead such evidence, especially since Ms. Armstrong was unconscious when the injury occurred. The non-negligent reasons that were proposed to the trial judge were considered and then rejected. And at trial, there was no issue that Ms. Armstrong's ureter injury occurred as a result of her colectomy. It was accepted that Dr. Ward used a ligature within 2 millimeters of the ureter. And additionally, while this did not happen in the case at bar, it would be possible to determine factual causation, what happened, and then determine that the standard was actually not breached. Hence why hindsight bias is not an issue here. The appellant rests. Thank you.
Thank you. Thank you, everyone. This concludes the matter of Armstrong and Ward. Could I please ask the judges to send their factum score sheets in as per the instructions you've received prior?
Is it the
that
factum
concludes our-
score sheets or the oral score sheets?
I was advised factum score sheets, but perhaps you could check with your contact.
Yeah, I think there was a separate group scoring the factums, and then we were to score the oral arguments.
Oh, okay, thank you.
That's my understanding as well.
Now, do you know, are we supposed to confer and put one together for each, or are we all sending in our own?
We have to send in our own, no conferring.
Okay.
Yes, that's right. Okay, our session is now concluded. Thank you, everybody.
Thank you, everyone.
Thank you.
Everyone.
Good job, everyone.
Yeah, good work. Very well done.
Thank you.